Bay Area legal experts are weighing in after the U.S. Supreme Court announced it will hear arguments over a law that could overturn the landmark Roe v. Wade decision establishing a woman's right to an abortion. KPIX5's Kenny Choi is live at the Ninth Circuit Court of Appeals in San Francisco this evening. Kenny?
Liz, the arguments in December would center around a Mississippi law that would ban abortions after 15 weeks. Now, some argue that this could be an early signal that the U.S. Supreme Court is considering overturning the 1973 ruling Roe v. Wade. Either way, it's triggering reaction from both sides.
Our constitutional protections, as we've enjoyed them, are a real threat like never before.
The 1973 Roe v. Wade ruling declared a woman can terminate a pregnancy in the first 6 months when the fetus is incapable of surviving outside the womb. Mississippi's law banning abortions after 15 weeks would test whether states that ban pre-viability abortions are unconstitutional.
15 weeks is very significant because they're saying we want to protect life before viability. And historically, the Supreme Court has not allowed states to do that.
If the Mississippi law is upheld, abortion providers argue the ruling could pave the way for other states to enact more restrictive abortion laws or even ban it entirely.
Other states have now seen a pathway to what Texas did, and we're bracing for what that impact is.
Previous court rulings have established states cannot ban abortions before viability, which is between 22 and 24 weeks of pregnancy.
Concerns for abortion rights activists is that if 15 weeks is okay, what about 8 weeks? If 8 weeks is okay, what about 6 weeks? It's the nose inside the camel problem.
Teresa Collette is a professor of law at the Pro-Life Center at the University of St. Thomas, Minnesota.
The premise of the argument before the Supreme Court by the state of Mississippi is that abortion itself is not a constitutional right that can be found in either the text or the history and tradition of this country.
Kenny, is there any way the pending ruling in the Supreme Court could affect abortion rights here in California?
So even if the Supreme Court were to overturn that ruling, the state laws in terms of abortion would be determined by state lawmakers here. Here in California, those laws have been firmly established through the state constitution, and given the level of support by state lawmakers for abortion laws, these laws here in California are unlikely to change. By the way, there are more than 100,000 abortions in the state of California every year.
All right, Kenny, thank you.